is really another testament to the excellent quality of folks that they're bringing here to Case Western. So I'm really grateful for their work. We have a really diverse group of scholars, economists, general counsel, sociologists, law professors, to discuss the new networked economy that is prevailing in manufacturing and biopharma. And of course, as is often the case, the Law Review, Case Western Reserve University Law Review, will publish a LEET Symposium edition featuring many of the papers that will be presented here today. Our keynote speaker to get us started off is Professor Matthew Jennejohn. He is currently serving in the newly established Office of Strategic Capital at the United States Department of Defense through an appointment at Johns Hopkins University's Applied Physics Lab. He's on leave from his position as the Rulon and Marion Earl Professor of Law at Brigham Young University School of Law. His research analyzes the relationship between legal institutions and equitable economic growth, with a particular focus on mergers and acquisitions, technology alliances, contract theory, and corporate governance. And those that are in those spaces know that Professor Jennejohn has rapidly emerged as one of the leading scholars in the country on those issues, is producing really cutting-edge scholarship that is helping to define those areas of study. His work has been presented in leading venues such as the American Law and Economics Association annual meeting. He's had numerous top journal placements: Stanford Law Review, Northwestern Law Review, Journal of Corporation Law, Georgetown Law Journal, among many others. He organizes, among other things, when he's at BYU, the Winter Deals Conference, which is one of the leading gatherings of corporate law scholars and practitioners, where they share cutting-edge research on issues central to the operation of modern markets. He also, of course, teaches classes on M&A, business organizations, contracts, and a seminar on new market infrastructure. Just by way of background, he has also served as a visiting professor at Columbia. He practiced in the New York office of Shearman Sterling and was a law clerk to what I think should be considered the leading corporate law jurist of recent times, Leo Strine of the Delaware Court of Chancery. He's a graduate of Columbia Law School, the London School of Economics, and my undergraduate alma mater, Brigham Young University. His keynote is going to be on relational contracting and industrial policy. He explores the origins of relational contracting, in which repeated deals and trading between parties introduces the conditions that make informal or extra legal enforcement of those contracts possible. He will highlight the increased role of state intervention in the economy and address what role relational contracting might play in this new economy, including helping state actors fine-tune their market interventions. He will highlight flexibility in contractual relationships as an overlooked element that may improve the role that macroeconomic policymakers play in the economy. So he will do a much better job of explaining all this than I have, but please join me in welcoming Professor Jennejohn.
All right. Well, that's very lovely. Thanks so much, Dean Rose, and thank you all for coming. I grew up not too far away from here in Wisconsin, a rural part of Wisconsin, where I learned in grade school sort of a useful self-preservation strategy was not to signal any sort of intelligence on the school. During recess, and only to signal your love for the Green Bay Packers. So I always get this always like triggers my survival instincts if somebody says something nice about me. So that's very nice. It's also I just want to thank everybody, particularly Juliet and Patty, for all the help, and for all of you for coming today. It's an honor And it's just great to see many old friends and to make some new ones. Lastly, I will, because I am from the Midwest, as I was coming in from the airport yesterday, I was just reflecting on how nice it's to be back. About a month ago, I was doing some interviews with a couple of co-authors. We were asking some questions of some lawyers about liability management in distressed debt situations. And without kind of taking you through the research, there was a moment in the market where what was perfectly legal to do under your contracts, but nobody did it, switched to somebody. Suddenly, everybody in the market said, "Oh, well, we'll take advantage of those contractual provisions." And the questions we were asking were, well, like, what caused that shift? Like, why did everybody suddenly on day one, they wouldn't do this thing, and on day two, they decided to do it? Were there reputational constraints? So it's a, kind of a relational contracting concept. And we were talking through that, and we were sort of pushing the interviewee over and over, like, really, was anybody worried about it? And the answer was no, really. Private equity just wants to make money. And then there was a long pause, and they said, I suppose if it was a Midwest deal, there would have been some thinking hard about this. And I was so validated in that moment. It's like, yes, the Midwest. So apparently the last place where morals matter in the market. So I'll jump into this. We've got some slides up here. I sent these slides to Patty before fully proofreading them, so you'll note a couple mistakes here and there. So thanks for bearing with me. The other thing I'll say is I know keynotes tend to be sort of formal. I'd be delighted if people want to ask questions as we go, and I'll provide some time also hopefully at the end for Q&A if that's interesting for you. But if there's questions that pop up, don't hesitate. Happy to just make this a more interactive experience. So what I'm envisioning for this paper, this is very much a work in progress, which just means your input will definitely be put to good use, is an exploratory essay, which is a chance really to think more broadly about relational contract theory instead of kind of dwelling on the debates that we've been having over the last several years or even decades, and trying to think further afield, what might it mean for the future? The essay will be directed, I think, particularly to legal scholars. As we know, this is an interdisciplinary area where we combine legal scholarship with social sciences. That's been the practice for decades. I think that's what makes it really rich. What I'm trying to do is really focus on sort of dilating the aperture, widening the aperture for legal scholarship here. I think it's simply, one way to understand this project is really just to say that there could be or should be a new audience for normative arguments in from the legal side of relational contracting research. So if we've been traditionally focused on courts, of course, that is sort of the modal unit for our normative claims in legal scholarship. And maybe some of us at least think about trying to help transactional lawyers with their deals. Maybe there's a new audience, which are, at least in the United States, will be the a variety of federal agencies involved in industrial policy. I think at this point I should note, as noted, I do have a role both at the Department of Defense through the Applied Physics Lab. None of this reflects any opinions of the department or the Applied Physics Lab, or maybe even myself. But so this is just my own thoughts, pretty far afield from any specifics that we're involved in at the moment, and all the issues that we'll pull or that I'll focus you on here just pulled from publicly available research. So I think there's two, what we're going to see over the course of these slides are two areas where relational contracting theory might have something to say for this new wave of industrial policy that has certainly been, industrial policy has been alive in the United States for a long time, but at least this is on the forefront of public policy discussions right now. One place where perhaps relational contracting theory might make a difference is how opportunities are selected within these programs. That'll be topic one for this. And then the second is when we actually get to the moving parts of executing industrial policy, perhaps relational contracting has something to say there. Those are sort of conceptually divided, I think, just to try to provide some clarity. In reality, I think those two things are blurred, as we'll kind of talk through, but at least to give us a bit of a landscape. That's it. I don't know if I can advance the slides. Oh, I can. All right. Here we go. All right. Oh, it didn't quite work. Well, so there might be a couple of hiccups as we go. So I wanted to start just with some framing, and this slide is really just about the conventional wisdom that we encounter, I think, in contract theory, and at least some of this is what we teach our students, and maybe some of it is what you cover like in an advanced contracting course. But we'll start, at least I start my first year contracts class in the first week asking, like, what is contract theory good for? And one way I teach out of Bob Scott and Jody Cross's book, one of the things we talk through is what we're trying to explain in contract theory is this puzzle of why some promises are enforced and some aren't. And that's the focus. Not every promise is enforced through the course of power of the state. Donative promises or gift promises aren't. Promises supported by consideration are. There are, of course, a bunch of fun cases in between that we noodle through. But that's the puzzle. And in the first year contracts class, the enforcement apparatus is largely assumed. We're going to be looking at federal and state courts, mostly state. And one of the ways to understand relational contract theory is just to test that assumption. And I thought I would start us out with the classic paper, Stewart's famous 1963 paper, which is hard to summarize just in a simple little box like this, but at least the way I've heard him talk about it and also write about it later is as follows, which is there's a written contract that you sort of stuff away in the filing cabinet after it's been executed, and then that's the paper deal. And then there's the real deal that governs the parties' contractual relationship. And this doesn't emerge directly out of his original paper, but over the years, I think one way to understand this is that relational contracting is an alternative or a substitute for the formal legal system. And the other foundational piece of work I wanted to point everybody to is Ian McNeil's idea, which I think is a bit different. And it's, I think, the primary innovation that Ian provided was this idea that actually the terms of a formal contract can be a site or where relational contracting is shaped and governed. It's the terms of a contract or a written contract. The paper deal itself can be part of that apparatus that the parties create that combines formal legal terms and relational governance. And it's anchored in the contract itself. So in this world, the relational contract, the informal social dynamics are complementary to the formal legal system. And I think that's going to be kind of bubbling under the surface of this talk as we go. So over the years, the big debate has been, one way to understand the debate is between those two sides. Like, are these substitutes, are they complements for each other? What's the relationship between informal and formal tensions? And that's just a bit of framing. The next slide, I think, is quite a bit different. And I think this might be one place where I just think, I'm sorry, I guess some of the formatting didn't work on these slides that well. This is just an area where I think perhaps my views differ a bit, maybe from the conventional wisdom in the literature. And the idea here is just that some of those social dynamics that provide sources of informal sanctions in the market, so the spread of reputational information within a market, we also see similar dynamics when it comes to the design of contracts. So this line of research, there's different starting points. Actually, the earliest work in this area is actually in corporate finance. But Mike Klausner's piece, 1995 piece, I think is a useful place to start. Looking at first at the design of Delaware corporate law and specifically corporate charters, the dynamic that Mike identified is that we have path dependency within the design of contracts. That work has spread to other domains. I think most famously it's me too and Bob and Steve's work on sovereign debt, where what we see are situations where there's highly sophisticated lawyers who are incredibly well paid, reusing standardized terms over and over in a very sophisticated market. And in some shocking moments where it actually seems like the terms that are used are inconsistent, perhaps, with the incentive or the interests of the parties to the contract itself. And they explain that this is, they explain one way to understand this is their network effects. So you get returns to reusing language over and over for a number of different reasons. I think the most obvious one is if you're using quote unquote market terms, your counterparties are more comfortable with, they're more comfortable with you. Just to highlight, I think what the social dynamics might do in these situations. I just got a brief summary on the right-hand panel here of some work that I've been doing with a couple of co-authors, Christina Bishop and Cree Jones. And what we're highlighting here is just how sometimes these social dynamics don't just lead to stasis. It's not just, oh, we're trapped in a standardized term that's really difficult to change. But even in situations where there's contractual innovation, it follows diffusion patterns that we see in other settings, like the diffusion of a technological innovation, or to make it a little bit more, close to home for all of us who went through the pandemic, it's kind of like the diffusion of a disease or the spread of a disease through a population. So the brief summary on the right here just captures the adoption of what's called a top-up option. This is a rather obscure deal innovation that happened in late 1999, early 2000 in the M&A market, where there are two-step tender offers. And without kind of taking you through the nitty-gritty details of the top-up option, I'll just say that it was a new deal innovation. And it started, there's kind of two places where it started. One was at Skadden Arps Washington office, and then Potter Anderson in Delaware, sort of both created this option. And what you see on the top chart there is just the adoption pattern for the top-up option over time. There's a very slow start, and then it spikes sort of roughly like the S-curve, if you're familiar with diffusion studies. Kind of like the typical S-curve that you see, like whether it's in the adoption of a new technology. What the bottom panel shows you is just the spread of the option among law firms within the advisory market in M&A deals. And we're going actually from 2001 to 2004 to 2007 to 2010 by the time you get to that lower right-hand network graph. And all you're seeing there is you see black squares. That's just those are firms that have adopted the top-up option and the deals that they advise upon. You kind of see that spread over time. For a contractual mechanism like a top-up option, which is joint surplus enhancing for both parties to the deal, what we find, we estimate some regressions, what we find is it's that proximity, that working together between firms in the network is what correlates with their adoption of the option. So it's really just to say that these social dynamics that we see first in relational contracting literature can also affect the design of the agreements themselves. We're not even getting to the enforcement question, like whether it's informally or formally enforced. We're just saying like what leads to the use of particular governance mechanisms. Perhaps these social networks are a part of that. Okay, that's going to be a kind of an important point as we come back to things. Oh yeah, yeah.
It's okay. It's non-lawyer. So this is really interesting, and you mentioned that sometimes this use of standardized terms is inimical to the interests of the parties. Yeah. And I guess so. Two questions, I guess. So one is, what's an example of that? And second, do the standardized terms always have the same meaning? Because you could also imagine that the meaning changes in different contexts.
Yeah. So on the first question, the best example, this is the work on sovereign debt that me too and Bob and then Steve Choi joined on. Now, off the top of my head, Sue, I'm not going to be able to give you a great example of like what exactly is a good sovereign debt indenture term that's inconsistent with parties' immediate interests. I just don't have that off the top of my head. But essentially, I mean, I think the dynamic might be clear enough where it's just, well, maybe let me just tell you a story. But this is the dynamic that we see in sovereign debt. When I was a young corporate lawyer, we had an M&A agreement markup that we were working on, and I was looking through this document, and I thought it was just an unholy mess. And I put on my thinking cap and stayed up late that night and reworked about 3 pages of documentation. Right? I think we all have. If you're a young associate, I think we all have this moment. And you take it. I emailed it to the partner. He called me in the next day. And it's just like, what on earth do you think you're doing? This has been agreed upon. This is what the market expects. If we start getting creative here, it looks like something's wrong. So we're going to stick with our standardized terms. And I knew, I still know, that actually it was a surplus enhancing set of changes that I introduced. And it would have been better for our client, would have been better for the other side also. But we just weren't going to do it because it might be read as a signal. So that was an antitrust risk shifting provision in an M&A contract. You remind me, what was your second question?
Just whether those standardized terms would have different meanings in different contexts.
Oh, yeah. The thing I wanted to so yes, there's some of Bob and Me Too and Steve's work talks about what they call like the encrustation of terms over time and how the meaning gets lost to memory. So they talk about in their book, The 3.5 Minute Transaction, which is a wonderful book. There's a moment in the sovereign debt market where they've been reusing terms for so many decades that none of these high-priced lawyers actually remember what exactly this term is supposed to mean. And there's a debate, and they did interviews and they asked, like, what does this term mean? And they'll get answer A out of one fancy lawyer, and then they go to the next fancy lawyer, and they give them interpretation B, and on it goes. And eventually this gets sorted out in litigation, but that's just an example. I think the answer is clearly yes, the interpretation can be different, but in fact, like the very people that design these contracts can't agree on what this term actually means. 3.5 Minute Transaction. It's a short little book. It's really nice. Really great piece. Yeah. Yeah. Other questions just on this one. Sorry, I've learned from teaching that I like the right-hand side of the room here. So you guys can shout at me. Yeah. Okay. We'll come back to some of these dynamics as we go. Oh yeah. So this is just the possibility that there might be some new questions to ask. So I think we're in a moment right now. I actually don't. I don't want to take a position as to whether the durability of this moment is a question. It's really hard to say. But at the very least, there's a lot of activity in a variety of jurisdictions, but especially in Washington around industrial policy. You've got some examples on the right-hand side of this slide of current initiatives. Where a tremendous amount of money is being spent to incentivize investment in a variety of industries. The graph on the left is just an example of like geographic investment in various technology hubs around the country. Most of it's from the CHIPS Act in this particular Brookings slide, but there are other programs. And whether this is, I think it's oversimplifying to say, we're shifting from this neoliberal moment, this equilibrium, to a new equilibrium. Usually change is a lot noisier than that. And I don't, it's kind of outside the scope of this talk to try to make a claim as to what the emergent new consensus is. But at the very least, there is an attempt for change, and what we used to leave to private investment is now either complemented or substituted with public investment. And so that makes, I think, things exciting. There are also a lot of new questions. And really here, all I want to ask is, like, is there a role for relational contract theory within this brave new world? One possibility is the answer is no. Like, this is all state driven, and the idea of private ordering and that's all just kind of old news. And really, we just need to ask a new set of questions with a new set of tools. And I'd like to push back on that assumption and just raise the possibility that actually some of what you might think of now as like the old learning might inform some of the things we're doing in this new policy landscape. I think I think also one of the assumptions behind like what I just described is that relational contract theory is actually of a piece with that sort of neoliberal moment of the late 20th century, which certainly isn't where it started. If we go back to the Macaulay and the McNeill era, this really arises out of legal realism, which is, and then there was, without taking you through all the intellectual history of this, there was this pivot within law and economics that took some of these ideas and I think reshaped them in ways that were consistent with that, that more neoliberal picture of the economic order. So that's all to say that there are a lot of assumptions baked into this slide, but at the very least, in this sort of broad brush way, I think we might be at a pivot moment where there are some questions about what was relational contract theory, at least in recent decades. What might that mean now as we're in this new era? So the two possibilities that I want to raise is one, kind of like, I already gave this to you, but just to remind everybody, one is like when perhaps relational contract theory might help us with the selection of opportunities when any decision maker, any state decision maker is deciding where to focus their particular industrial policy. That might be one thing that relational contract theory informs. The second thing is just actually when the state then moves to execute, perhaps relational contract theory has something to say in that point. And of course, again, these are just kind of conceptually separated. In reality, I think those are both interwoven. Oh yeah, we got some two different versions of PowerPoint, I guess. So the first thing I wanted to take you through is this idea of opportunity selection. So when a decision maker, a state decision maker, is thinking about where to focus its money, where to focus its effort, it has options before it. And it would be nice, I think we all agree that it would be nice if they focus that investment in the most optimal option before them. And one way to understand the option set is, this is just a line of literature, there's certainly other ways to think about this, is perhaps what we should be doing when we're focusing state money on investment is we should be intervening within a market, within a production network in places that are vulnerable. So then you have to say, well, how do we define vulnerability? Coming out of the global financial crisis and then later the COVID, the pandemic crisis, one way to think about vulnerability is if there's a shock to a market, how does that propagate? So you can think about like, what if Lehman Brothers crashes? How does that propagate through a financial market, for instance? Or if there's a global pandemic and we shut down all the suppliers, how does that shock propagate through a market? And there's some really interesting work. There's a number of people working on this. I think Matthew Jackson and Ben Golub and Matthew Elliott are good places to start. And I've got some of their work highlighted here. And these are just macroeconomic models that combine network analysis to try to start understanding in a more fine-grained way how that shock propagation spreads. So where does relational contracting fit into all this? So here's a couple of ideas. If you look down at the bottom panel, what you have is a very simple network. And this is taken from the Golub and Elliott work. The basic idea here is that as you introduce additional sources of supply, you should get more resilience within a network. So if you look at panel A, imagine you have a customer that's the yellow node at the bottom who's single sourcing its supply. From one tier up to the next. Everybody's just getting a single source of supply for whatever the input is coming down to the yellow node, whatever they're buying. And that leads to a certain level of reliability. If you look at the graph on the upper right-hand panel, you'll see that the lowest curve, the blue curve, you get sort of a modest level of reliability within the network. In other words, if you have a bunch of single supplied nodes in the network and one of its suppliers fails, then the reliability of the network is fairly low. If you look at panel B on the bottom, this is a situation where the customer is sourcing from two suppliers, and it's sort of intuitive, right? So if one of the suppliers fails, I can always turn to the second one, and I have a more resilient supply base in that situation. Panel C just introduces the insight that actually network structure matters, that if you dual source, but it turns out that both of your suppliers are sourcing from the second tier, same suppliers, then you actually might not be that resilient at all if the failure happens within that second tier. It's all just to say, like, perhaps network structure matters. And I suppose relational contract theory might have something to say about how those links between nodes actually are chosen. And I think I'll just say, like, to the extent that relational contracting theory and legal scholarship has always been in the spirit of expanding our sort of disciplinary boundaries, I think it's a useful place for legal scholars to start making a contribution. Like, perhaps the formation of contracts, whether we think of them as relational or formal legal agreements, will shape how those edges between vertices within the network are actually made. I think that's probably one of the, I think there are other things we can do also. So just to kind of finish this thought and get to what I think is the bigger payoff on this slide, if you look at the graph in the upper right-hand corner, what you're seeing are just simulations that say, well, if there is multi-sourcing in the network, then it is more resilient, right? That's all those curves describe. So here's what I think is actually much more interesting. And I couldn't find any nice pictures for you, so I'm just going to talk you through this. There's more recent work that Elliott, Goldman, and Leduc have done, which says, let's model the propagation of a shock through a network. But one of the things we're going to incorporate into that are the characteristics of the edges themselves. So if you look at that bottom pattern, or that bottom set of graphs, we just have nodes and we got some arrows, and the arrows would represent the contractual relationship. And what this more recent work does is say, well, what if there's particular aspects of those contractual relationships that might provide some flexibility, right? So if I'm under distress, or if I have a supplier that's under distress, perhaps the quality of the contractual relationship might affect the spread of that distress through the system. And maybe, like, a very rough and simple way to think of it, what if I have a relational contract with a supplier and they become distressed, they're approaching insolvency maybe, or whatever the problem may be, and we have a mechanism for working out those problems over time, maybe that'll affect the spread of a shock through the system. So it's just to say, like, here's a point where the formal modeling is always, sort of rough when it comes to institutional details. Maybe this is a place where actually the rich institutional detail that a legal scholar can bring in would improve the formal modeling that the macroeconomists are doing. Again, I don't have pretty pictures to take you through that, but I think that's an important thing. The implication is, if we can improve the modeling around this and better understand vulnerabilities within a market like this, that's where we can then more finely direct state intervention to, for instance, improve resilience across the market. That's one possible idea. Okay, I'm sorry, we got a lot to click through here. Yeah, the second thing is this, I think, this more geopolitical turn that's happened in markets recently. And I thought I would just kind of give you, sort of preface this discussion with just how I personally discovered the importance of intellectual property rights in these types, in what we call relational contracts. Excuse me. So I started thinking about these contractual relationships when I was in law school. I dug through the available economic literature in this space, and all of it focused on really the two forms of economic organization. One is the firm, or the company, a corporation, and then there are the contracts that they might use. And the question that Coase originally raised, and a number of people got Nobel Prizes for, in addition to Coase, is this question of, when do you choose a governance mechanism that's contractual, or when do you govern economic activity within the boundaries of a firm? And those are the two options. And I went into practice. I was doing M&A work in addition to some antitrust work. And in all that spare time I had, I would occasionally set up a conversation with an M&A partner to talk about the way I framed it was strategic alliances. That seemed to be like a phrase that they would grab onto. And when I went to the first few M&A partners, we'd sit down and I'd ask them about the alliance contracts that they had negotiated and their familiarity with these ideas. And what I heard were stories about airline alliances or credit card alliances, and nothing about the technological collaboration that I thought would be natural for them. And after a while, finally, one of the partners said, well, who you need to talk to is our intellectual property transactions group. And I thought, well, what on earth is that? Right? I didn't even know that existed. So I went down and started talking to those attorneys. And it was exactly, they dealt with exactly the problems that, at least from the literature I was familiar with. And what I understood to be the central question in these, one of the central questions in these contractual relationships was, how do you allocate intellectual property rights between the parties? And particularly, what do you do with intellectual property that's created through the collaboration itself? And it turns out that there's a rich literature around this, both, among some of the people in this room who I've learned a ton from, like George and Peter and Liza, and then there's a rich practitioner literature around this. And I think one of the key takeaways from that literature is that the simplistic setup where there are firms who I think we assume just own the intellectual property that they have, and then there are contracts where they create contractual obligations and they may allocate intellectual property between themselves, is actually a lot more complex, particularly when it comes to like the joint ownership of intellectual property that's created within a contractual collaboration. It's just to say that actually the boundaries between the firm and, between firms and the contractual links between them can really be quite fraught and at least complex and something to puzzle through. Why does any of this matter? So to take you through this slide, I think we'll get to why some specificity around intellectual property licensing and ownership really matters. So what we have here is my attempt to summarize a really interesting working paper that just came out a couple of months ago from Clayton, Maggiore, and Schrager, who are three financial economists. And what they note is that within production networks, while we used to kind of think of these as opportunities for increasing collaborative innovation, what they also do is they provide control points where like a geopolitical hegemon might be able to put pressure on companies within the network. So what you have on the right-hand panel is a very simple setup where imagine there are two upstream suppliers, that's node J and node K, that are providing some inputs down to customer I. That's the lower left-hand node. There's this other node which is crossed out, and that's going to be sort of, we're going to keep that in the network and we're going to pull it out and think about the implications. So in the original setup, imagine that the node that is now crossed out actually exists. If a country controls both node J and node K and tries to cut off the supply to node I, but the lower right-hand node exists, then there's an alternative source of supply for I, and the attempt to influence will be difficult. If, however, you remove that node so that the only sources of supply are those two nodes that are controlled by, for instance, the United States, for example, is one of the countries that they model within the paper, then you have the ability to put some pressure on a downstream customer. The simple implication here is like where control is within who holds that control, and this is where intellectual property can be a particularly powerful tool, matters in this geopolitical sense. And the ability of a state to direct companies that then control that intellectual property can have geopolitical implications. And this simply in the sense that if relational contract theory can illuminate these control points, understand how they're both defined within a production network and then transferred and created over time, then we might be able to more finely tune our understanding of how these geopolitical dynamics operate within these markets. I'll say it's this line of research is certainly prescient from if you read like the Wall Street Journal or the Financial Times these days, but it is one of the larger departures, I think, from at least the way I thought about production networks 10 years ago when I was starting my academic career. It's a very different lens to approach the whole enterprise. Okay, that's going to be it for opportunity selection. So just to summarize, maybe what we have is a way to think about vulnerabilities. Maybe relational contracting can help us think about that, whether it's vulnerabilities within a disruption within a production network, or maybe it's vulnerabilities to geopolitical influence and manipulation. Here are those two ways that relational contract theory can make a difference. Okay, then the next thing, and this is where I just wanted to highlight, like, really these aren't conceptually distinct for the reasons I kind of highlight on the left. If you're a state actor trying to decide where your opportunities lie and how to choose between them, I think it's safe to say, at least right now, that this is a high uncertainty environment. It isn't fully clear exactly, the choice set isn't fully clear itself, and then the trade-offs in between choices within the set aren't, I don't think, are obvious in many cases either. So it's a discovery process. You're trying to, it's a process of collective learning, within the state actor, but also to the extent that they're collaborating with private parties, then there's collective learning within that also. We've developed, within relational contracting research, we've developed a way to talk about this in that private sector context. I think Gilson, Sable, and Scott's characterization of this as contracting for innovation is a useful way to think about it. And the idea is simply that when it is quite common for commercial parties to say to themselves, we would like to develop, say, some new technology, the characteristics of which aren't particularly clear right now. And it's difficult to create clear enforceable contractual obligations that explain exactly how we're going to create that new technology. So it's a highly incomplete contract that would have to be designed. And they identify certain characteristics of the agreements that parties use to govern those collaborations when they can't clearly pin down performance obligations. Some of the hallmarks of these things are the use of governance committees where there's consensus decision-making, the inclusion of milestone progress, and then payment schedules attached to that, particular types of termination provisions. One of the basic ideas here is that perhaps the concepts we've developed to understand private sector collaboration can be adopted in the public sector context. And so here, just for inspiration or as a foundation, I think the recent work by Mazzucato and Roderick, focusing on how industrial policy is typically accomplished through deals, is a useful way to think about this. It's certainly a lot of industrial policy is just like a simple grant, for instance, or a loan, which contractually is not, may not be particularly complicated. But there are other moments where the contractual engineering is really quite complex. And that's where perhaps I think there's an intersection between relational contract theory on one side and state action on the other. So on the upper right-hand corner of the slide, all you have here is the idea, this is Mazzucato's and Roderick's idea, that what we're trying to create is an entrepreneurial or developmental state that has that ability to innovate with the private sector. And in the lower right-hand corner, all you're seeing is the description of one possibility of how, at least in the United States, this is accomplished. And that's this idea of other transaction authority. This is a relatively old thing that developed developed for NASA's use decades ago. And I've got some slides just to show the uptake in a second. But just to kind of cut to the quick of things, if you have in your mind the contracting for innovation idea from Gilson, Sable, and Scott's work, and you look at an OTA, which is this other transaction authority contract, the similarities are striking. Those kind of hallmark provisions, like the idea of a governance committee, the milestone progress, the particular termination rights, provisions worrying about the ownership of foreground IP. what we see in the private sector is replicated in the other transactions and in a pretty striking level of similarity. It's just to say, I think what we're seeing is this natural contractual innovation process. So you think of that like the diffusion I showed you on slide 3 of this deck, where you have a new innovation diffusing through a market. We're seeing the same thing on the public side. So let's just kind of take you through a few things. So I'm at that age now, apparently, where it's hard for me to read at that distance. So you'll forgive me. I'm gonna turn my head a bit. So on the upper left-hand panel, you just see, and this is just GAO reporting on the incidence of OTAs across this slide deck. So this is just federal government reporting on their own activity. What are most other transactions used for? It's over 75% of them are used for research and development, which is unsurprising. It's just to indicate, yeah, these are situations where innovation is happening, and the U.S. government is using a novel contractual form to accomplish that. Who are they doing it with? That's the lower left-hand panel. They're typically doing it with non-traditional suppliers. What we mean by that is simply that these are suppliers that aren't deeply embedded within the federal acquisition system and familiar with the FAR process. Usually OTAs are used to bring in new market participants into the federal ecosystem. These are kind of hard to read, but on the upper right-hand corner and the lower left-hand corner, you just have some graphs that show you the uptake of OTAs in recent years. I think the bottom right-hand corner might be the most useful. What you see in the orange part of the bars is just the uptake of OTAs outside of the COVID pandemic response, and then the blue bars are OTAs used to respond to COVID. So excuse me. So I think what we're seeing is that spread of other transactions throughout the federal government. These are being used often, and interestingly, these were turned to during the pandemic as a quick way to spur innovation. And I think what all I mean to suggest with all this is that perhaps taking the understandings from the private sector relational contracting literature, moving it into industrial policy might be a fruitful place for future research. The last thing I'll say about this is it's also possible, I think, for relational contracting to make a difference when it comes to understanding the combination of private and public sector parties in the collaboration, when they collaborate around a new innovative project. So again, this might be kind of hard to see, but if you look at that black, I wish they just used rectangles because I don't know what how to describe those shapes. But if you look at the black shape, that's the role that the other transaction authority plays as a foundation for a research consortium, this structure is used with some frequency in the federal government currently. And it's just to say, the better we understand the other transaction, the structure of another transaction, then I think what we'll be able to do, this is an area where legal scholarship can make a contribution in improving the operation of consortia like this. So in the hope that perhaps there's some questions or thoughts people want to share, I thought I would just sum up with this. So if our original question is, what is contract theory good for? Of course, I don't want to have an essay that suggests we should abandon everything we've been doing. Of course, the classic questions of how should courts enforce or how should communities enforce contractual obligations is still of critical importance. Like private markets are a robust and vibrant part of the American economy that we still need to understand in greater detail. The question here is more if we're in a moment of dislocation in American capitalism where the state can play a more forceful or more present role, then perhaps we should start thinking about what relational contract theory can mean for that problem set. And here I think the takeaway is actually understanding the role of relational contracting in the design of contractual relationships. So it's really to emphasize the design aspect. That's where there can be some contributions to these broader industrial policy issues. And that's it, my friends. That's what I've got. So you can start peppering me with questions if you have any.
So I'm not sure I need a microphone, or do I? But
Yes, yes.
here's my question.
Because-
Oh, because of that. So here's my question now. Well, really, we enjoyed your talk. It was fantastic. But here's my question. So can you give an example of the kind of vulnerabilities that you're talking about in which using the relational contract model would help inform state action or intervention in a positive way?
Yeah, yeah. So imagine, I mean, I think if we let's just use what I think is the most common situation, which is just supplier distress. Let's just imagine that's gonna be our primary concern. I'll say the way there are private sector tools around this now where OEMs will take some pretty they will contract with their with their immediate suppliers for visibility up the tiers to get to understand get early warnings about supplier distress. But let's say that's not like a full that's not a fully that's not a full solution to the problem, and we might say maybe there's a role for the state in situations to intervene in a market when distress emerges and we don't want it to spread. I mean, in financial markets, this is absolutely what we worry about. And I think right now what the models will do, I mean, the 2022 paper is just starting to do this, the Elliott, Leduc, and Golan paper. It's, if we're going to start thinking of contractual characteristics in that propagation model, then really right now, like, what does that really mean? It's just a very loose conception of like, well, maybe some contracts give you flexibility and some don't. Like it's a binary. And that's where I think actually getting the detail that I think we all appreciate as legal academics working on relational contracting, just the level of detail that we work at has a way to make a difference. So if I have the ability to say, it's not just a binary between flexible and unflexible, but really what we need to start trying to do is think about like specific characteristics around modification systems within a contractual relationship. So this is like the role, what does a governance committee allow either party to do in one of these relationships? Or what are the termination provisions and how do those rights, which we know are like, can get incredibly elaborate, like how do those actually work, and to build that into one of these models. I don't know if that's
helpful.
yeah. This is, I mean, I should just say this is very when I'm trying to look into the future, is a very self-conscious thing. Yeah, I know.
So first, I love this, and I think it's very relevant now because there's going to be this, I hope, big push with regards to industrial policy and innovation, right? I think it's time to start taking innovation into account. And I guess my question is, where do you see this play out with regards to the contracts? Because I know I have some thoughts about that, but I was just curious about where do you see that changing, or perhaps it shouldn't change, or
That's interesting. So in other words, like how would the state intervention start shaping like
Exactly.
the privately ordered contracting? I don't know. I mean, it's a fascinating question. I mean, certainly, I think the way we operate, the mental model we have right now is sort of that one-way transfer where let's start taking things from the private markets and start adopting them. That's sort of the framing I gave you all. But yeah, trying to anticipate exactly what, certainly there'll be changes. I couldn't tell you off the top of my head what I think they might be. That's a great, but did you have thoughts on that?
Yes, because I think the way we see that influence from the private to the public, I think we might have the opposite happening as well.
Yeah.
And I think that now perhaps is the moment where we're going to see those influences, but I could be wrong.
No, I think that's right. I think that's right. I'm sort of grasping at an example.
Yeah.
But yeah, no, I think that's right.
Thank you.
Yeah.
Thank you.
It's a great presentation. I really enjoyed this. A couple of questions, one a very basic one, and then the other one maybe a bit more advanced.
Yeah.
The first one, if you actually believe in relational contracting, does that mean that you can't believe in the parole evidence rule? Meaning that, you ought to be incorporating things external to the contract, that, essentially the drafters of the CISG got it right, where, there is no parole evidence rule under the CISG, and we ought to be using that as the American model. Second, in addition to that, thinking about your presentation, which was, absolutely brilliant and really well put together, one of the things that it made me think about is that Hayek quote, the curious task of economics is to demonstrate to men how little they really know about what they imagine they can design. If you're going to adopt a theory of relational contracting, in this world in which, you have the contract and then how people are relating is going to be very different. How do you go about figuring out how to do that on the ground? I mean, what sort of tools do you use for purposes of figuring out relational contracting rules and then adopting those into the larger space? Or is it one of those things where everything becomes so individualized that, it becomes difficult to really develop a coherent industrial policy?
Yeah, no, it's a wonderful, they're both wonderful questions. I'll work through them in order, but I think that second one is really insightful. I don't, well, actually, maybe I'll just take that on. I don't know. I'll kind of confess sort of my priors here. That actually I should have mentioned this a little bit earlier on the slide where I was talking about the Mazzucato and Roderick work. One way to understand the public side of this is through the experimentalism literature, which is, and this is what I'm going to attempt as sort of an answer, Eric, just very self-consciously saying this isn't a full answer at all. But one way I think to tackle some of that ambiguity and the complexity in engineering a new system like this is to sort of self-consciously say we're going to take a provisional incremental approach to this design process, and experimentalism I think is one way to understand just how that can unfold in the public sector. So actually I can just highlight Josh. Josh has some wonderful work. Josh, I don't remember the title of your paper about sort of the tenuous connection between ends and means.
Pragmatist, yeah, it's a horrible title.
No,
it's about pragmatist theories of action. Pragmatism, the untenable dualism of means and ends. Yeah. Why rational action theory does not deserve paradigmatic privilege. You can come up with a consistent theory of the rational actor.
You can model a consistent theory of the rational actor without reverting to rational action theory. If you think about the idea that if you change what the ends that you're pursuing, of course you change the means. You change the tools you use. That seems straightforward. But as new means become available, you're actually able to envision different possibilities. It's the idea that we have preferences over things we've never thought about. You actually don't have to assume that. Why would you assume that? And you could actually come up with a consistent sort of theory of the rational actor. It comes out of, I'm riffing on John Dewey with that one. So,
Yeah, and it's so I don't, maybe Eric is just to say like that at least gives us a way to think about navigating that design space, and that's probably what I've got for the moment. On the first question, this is a huge fun debate, and I'll just say, what's the scope of the parole evidence rule? I'll just highlight two thinkers here. One is, I believe it was the 78 paper that Ian McNeill wrote. If you kind of get to the back of it, there's a moment where he invokes the idea of polycentric approaches to litigation. And I don't think anybody talks about this anymore, but it's fascinating. And it's this robust, like, I'm going to wrap my arms around this whole problem. Like, a court adjudicating an interpretive dispute is going to wrap its arms around the whole relational aspect of this contractual of this agreement. And I think that's that expansive role. It's a little bit, if anybody teaches Roger Trainer's case, the PG&E case, it's a little bit like that. And I think it's a fascinating perspective. I think the other side of this, different people, I think can be attributed with this idea, but it's Bob Scott's idea that actually really what you should be using in these interpretive disputes is a formalistic approach to interpretation, because what that does is it prevents the state from basically botching the read of the relational contract. So if McNeill is saying, the court should put on its thinking cap and really try to understand the depth of this contractual relationship and it's all of its social detail. I think Bob's argument, again, others say this, but is like, actually, like, there's no way a court's gonna be able to pull that off. And really what you should do is if there's, before you take that step, you should enforce the plain meaning of the agreement and let the social sanctions work on the relational aspect. So that's how you would get complementarity. The thing I'll say about that, just a couple of things that I think are really interesting. There's a wonderful paper. I think this is like one of the most interesting papers written on contract theory in recent years, and it really there hasn't been a ton of engagement around it. It's Gilson, Sable, and Scott's paper from 2012. And I want to say, oh gosh, I'm forgetting the title of it. But what they do is they tie the characteristics of a market. So they connect contract design to the particular interpretive scheme. So for some markets, you should have this formalistic approach that I just described, kind of what I think of as sort of Bob's classic argument. But in other markets, you should do that contextual read. So it's really contingent on market characteristics, which is fascinating because really what we're talking then in the United States is you have market specific interpretive regimes. So it's a heterogeneous institutional design, which is really interesting to think about. Does that exist? That's a big empirical question. I think maybe they point to like this is a little bit far afield, but they point to the Delaware Court of Chancery, which uses equitable. You can think of that as a contextual interpretation of legal obligations as an example on one side, and then they'll look at like classic New York contract interpretation. Think of like of credit agreements as the formal side. So that's just it's not a perfect. Maybe one way to say it is like, I think that's really interesting to think about. And instead of taking a position on like, we should have a hard parole evidence rule or a soft one, I think that's a really interesting question that actually perhaps it's contingent on market characteristics. So those are both excellent questions. Yeah. Yeah.
We have to.
I got the mic. I might as well ask a question.
Yeah.
So one of the things that's interesting to me is you're talking now about the kinds of things that people learn in law school, which is how to do contract design, and what we can learn from this, how to bring in relational contracting theory. But I'm going back to your story about staying up late at night and redesigning a better contract and having the partner say, yeah, don't do that.
Yeah.
And you're now a lawyer in government on the doing industrial policy side. So the other sort of the flip side of this is relational contracting theory can inform what can be done in the context of contract, meaning interpretively what you need to look at, what you don't need to look at. So there's this sort of shadow of the court, and the other interpretive regime is where you don't need to bother with the court, or where you have to think about the agencies. And I don't know enough about the implications of the end of Chevron deference, but it seems like it kind of matters. Or maybe it doesn't, I don't really know. But so it seems like another aspect of where relational contracting theory might inform industrial policy is actually thinking about what lawyers can do in the context of contract and recognizing, sort of thinking seriously about, the kind of things that lawyers, you can say like, you go to a lawyer and say, yeah, they're just never going to sue you there because you don't have any money, right?
Yeah.
Those kinds of things that legal training or understanding of the world of law that non-lawyers don't necessarily understand. Some of the things we were talking about last night about where you actually have interpretive leeway, where you don't, why. I mean, that seems like another place for relational contracting theory, maybe more in the Macaulay sense. Yeah. Macaulay, you're drawing sort of a distinction there, but there's elements of McNeil on that too. So that's one of those questions where sort of a statement I say, what do you think? So the question is, hey, what do you think?
Yeah, no, totally. And maybe just, actually, I kind of sublimated this, but, one way, I think the clearest way, and at least from what I've given you so far, rather than me kind of like scurrying off and giving you new examples, maybe just to kind of unpack this a bit would be helpful. So there's a way to contract in the federal government, and it's the federal acquisition system. And at least for this lawyer, it is just an unholy mess. It's just like, oh my gosh. I can't believe this is how this works. It's insanely complicated and very rigid. And we can talk about the social like there's a culture to it. And what other transaction authority is literally is a statutory basis to get around that. That's why it's like it's an other transaction, as in it's not a FAR governed transaction. It's an other transaction, this other thing, and allows a tremendous amount of leeway that you otherwise can't get within the formal structure. And as we saw, like this is incredibly popular now because it's a way to kind of get around those. Yeah, like the cultural and the rigid legal aspects of it. So that's it's a great question. It is a place where I think a lot of, yeah, you're right. Like a lot of these dynamics can actually inform that side of it. George or Peter or
So I really enjoyed your talk. And as the state becomes more aggressive in industrial policy, how do you think about tensions over managing knowledge spillover? So you've written about this in other work. Companies obviously don't want to disclose their information, but there is some public policy interest in widely sharing information. I'm thinking in particular about the government's contracts with Moderna. Obviously, we got a great payoff. We got a COVID-19 vaccine. Moderna got a pretty sweet deal as well, a lot of money, and they can retain all of their tacit knowledge, their vaccine recipes. And so how do you manage these tensions around knowledge spillovers?
Yeah, no, I think it's a huge issue, and I'll just say I think that, and this is just very obvious from all the public reporting. So the spillover aspect, which we used to think of simply, I mean, this is sort of a crude rendition of it, is okay, if I'm a private sector actor, I want to restrict spillovers and I want to internalize those, right? I want to exploit my unique capabilities, intellectual property, whatever. And if I'm a state actor, I'd like to increase spillovers, right? I'd like to let this spread, and this like we talk about the NDA debate, things like that. I think what's really tricky now is just to say, oh, in the current geopolitical reality, now the state wants to restrict spillovers also in ways that cross-cut the private sector interest in restricting spillovers. And I think, I mean, maybe at this point, I'll just say, like, it's really complicated. Just trying to think through that problem, because some private actors would like certain types of spillers to go a certain way, while state actors would like them to go a different way. And it's just, yeah, it's new territory. That's a great point, Peter. Yeah, George?
Hey, Matt. Hey, thanks very much. This is great. So, you're mentioning of the FARs and probably the DFARs are even worse. But it makes me think about this in light of some recent developments with OTA. And, the FARs and DFARs, for all of their rigidity and cumbersomeness, I mean, they do act as a set of guardrails that potentially like protect the public from bad contract lawyers in the government. And, I just in observing, say, for example, the Regeneron BARDA deal that recently was announced, I mean, it seems pretty clear to me that private sector lawyers are just drafting rings around the government contracting lawyers who are giving up a lot. And maybe they realize this, maybe they don't. But without the guardrails of the FARs, they can do whatever they want. And I think they're just getting creamed in terms of drafting skill and giving up the farm. And then, pretending that they did a great job. And so I'm curious, I mean, do you really see sort of the open-ended OTA authority as a good thing? And what should we do about it? And just get better lawyers, in the agencies to negotiate, or, maybe look back to some sort of guardrails within regulation so that not everything gets given away? I was curious what you.
Yeah, no, it's a huge issue. I don't, get better lawyers. Yeah, it's, it's all the all the limits that the federal government has in terms of hiring, you know, the needed talent, I think kick in there. So what can you do? I suppose, and maybe just a highlight for everybody, I think there's what we're identifying is there's a tension between the freedom that an OTA gives you and the ability to really keep the state side of that negotiation on the rails and sort of operating at the level that you would hope for. So, you know, this is probably a throwaway, George. I'll just acknowledge that up front. If you had, I think, a robust learning process on the government side, then I think that's probably the best shot you would get in terms, because the problem with the FAR process is it's just so slow. Like the updates are just slow. So, you know, I can't give you like a real estimate, but like by the time we incorporated the learning into the FAR system, we're probably talking years after the actual moment of learning happens. So how can you speed that up? You know, maybe, I mean, I guess that's just what the policy focus would have to be on. And I don't have, yeah, maybe I'll just say I don't have a view on how likely it is to actually accomplish that. So yeah, I think it's a really fair point. There are a lot of wicked problems in government, I'm finding. Yeah. Thanks everyone.